hello, and welcome to Crime in Court. My name is Heather, and this is an update in the Sandra Birchmore case. So, we've been following along. We've done a deep dive on this channel in the Sandra Birchmore case. We've gone through all of the court documents, including the civil suit that Sandra Birchmore's aunt, Darlene Smith, has filed against the Stoughton PD, the town of Stoughton, and the three, actually four former Stoughton officers, including Josh Heel. They added him on later, who was the animal control officer in Stoughton. So that's four: Robert Devine, Matthew Farwell, William Farwell, his twin brother, and Josh Heel, which we've talked about in depth already on this channel. As of August 28th, Matthew Farwell has now been arrested for the crime of homicide against Sandra Birchmore. Noticeably, there was no crimes of uh, harm to a minor, nothing along those lines, or abuse of his power. It was homicide of a victim or a witness, which she would have been both because she probably witnessed some things that were quite illegal going on with the some of the police officers. I think she probably knew some things about Matthew Farwell that he didn't want getting out. Not just what he was doing to her, but other things. I think he was talking to her about stuff. And I also think that I know she's a victim of Farwell's and others. And so she's a victim and a witness, and Matthew Farwell allegedly took her life, but he has now since been arrested. So that is good news. We've gone over his the 45-page motion for his detention. And speaking of his detention, we're going to get into that. We've got a lot to get into tonight. So please hit that like button and let's dive in. We're going to go over some talk of some secret meetings with the ME and the feds. We're going to talk about Matthew Farwell's motion for voluntary detention, which he filed this week, or this weekend, I should say, on Saturday. And we are going to also talk about some updates in the civil suit. So let's get started. Let me shrink myself here. All right, so I have a clip here from 25 Investigates. This is Ted Daniels is going to be reporting about a secret meeting with the medical examiner and the feds before Matthew Farwell was arrested. So let's see what Ted Daniels has to say about this.
Sandra Birchmore's death certificate still says suicide more than a week after a former police officer was charged with killing her. 25 Investigates has learned of a secret meeting about that discrepancy.
And he strangled Sandra Birchmore to death.
The arrest of former Stoughton police officer Matthew Farwell for the killing of Sandra Birchmore may have surprised some, but not Massachusetts Chief Medical Examiner Dr. Mindy Hall. 25 Investigates has learned the FBI had a lengthy meeting with Dr. Hall 9 days before. Sources tell 25 Investigates the feds wanted Hall to know their findings contradicted hers. How often?
Now, this is the second time in recent months in this year that the feds have said, hey, Norfolk District Attorney Michael Morrissey, we disagree with your medical examiner's conclusions, and we disagree with your conclusions of this case. This is not something that normally happens. Usually DA, you would think, prosecutors are out for the truth and justice. But in a lot of these cases, we are finding that they are trying to hide the truth and keep the public from knowing what's really going on. And that's a scary problem that we are having with some of our law enforcement and state agencies. So, yeah, it's crazy. Anyways, we're going to talk now, or he's going to continue questioning.
Investigates the feds wanted Hall to know their findings contradicted hers. How often have you seen a state medical examiner rule one way and then the feds come up with a completely different scenario?
I've never seen it. I would imagine that it's very rare.
State police
Never seen it. This woman was the former Suffolk County something DA prosecutor, it said. She's never seen it. She's never seen a medical examiner being told by the feds, hey, you're wrong.
completely different scenario.
I've never seen it. I would imagine that it's very rare.
State police detectives assigned to the Norfolk DA's office were the first to look into Birchmore's death. Former state and Suffolk County prosecutor Juno Perkins says the Emmy's determination that Birchmore hung herself would have been based on an autopsy and any evidence the DA's office provided,
Including things from the crime scene, witness testimony, and things like that. So the first question I would have is how much information the medical examiner had when they first made that determination.
Yeah, they are getting their information from law enforcement, from the DA's office, from Lieutenant Fanning, who was in that text chain with Michael Proctor and laughing and liking things that he was saying derogatory about Karen Reed. Lieutenant Fanning was head of this investigation with the Massachusetts State Police. We also know that certain Canton police officers were first to arrive on scene, including, I believe, Sergeant Good, Sergeant Lank, Kevin Albert, Brian Albert's brother. So do you see how this is all entwined? Karen Reed, Sandra Birchmore, crazy. All the same people involved.
The Emmy ruled suicide in May 2021, roughly 4 months after Birchmore was found in her Canton apartment with a duffel bag strapped connected to a closet door around her neck. At the time, the Emmy should have known Birchmore believed Farwell was the father of her unborn child, and he was the last one seen entering her apartment building in this chilling surveillance video.
And he used his knowledge and experience as a law enforcement officer to stage her death to look like a suicide.
Part of the new evidence collected by the FBI includes an analysis from Dr. William Smock, chair of the National Medical Advisory Committee for the Training Institute on Strangulation Prevention. Court documents say Dr. Smock cited Birchmore's
He's the other. So there were two forensic pathologists now that have ruled her loss of life as not a self-deletion, but as a homicide. Someone else's hands took Sandra Birchmore's life. And that has been ruled now by two forensic pathologists, the one from the FBI and the one that was hired by the Birchmore's family for the estate of Sandra Birchmore. So that is now two. And one is Dr. Michael Bodden, the world-renowned leading autopsy dude. So with that said, now we know this was strangulation and not self-hanging.
hyoid bone fracture, the pattern imprint injury on her chest, abrasions on her nose, and the broken necklace, among other evidence that led him to conclude that Birchmore's death was a homicide. A spokesperson for the Emmy tells me cause and manner of death is based on the information available at the time of the determination. We ask if Sandra Birchmore's will be reevaluated. This is part of the answer we received. As with every case, the OCME will review its finding as new information arises and awaits access to any newly established evidence developed by federal and state authorities. For 25 Investigates, I'm Ted Daniel.
So basically, they just said we couldn't have determined that. We couldn't have determined that unless we had the information. But you had all the information. The Norfolk District Attorney's Office had the same information that the feds used to indict Matthew Farwell. Nothing new has come out, nothing different changed. There's nothing that the feds did any differently other than they actually charged the guilty. Whereas apparently, if you are a cop and you work in the Norfolk District Attorney's Office, you can get away with literally taking the lives of people. because that seems to be what was going on here. So, as you can see, secret meetings, FBI with the ME. The ME is told, hey, remember that self-deletion you ruled here? How'd you get there? Because we disagree with you, and we have many reasons to believe that something is amiss. So, can you imagine being the ME and having the feds come and meet with you saying, how did you get to this determination? And what other information were you given to conduct your findings? Because like I was saying earlier, the problem is the ME, the medical examiner's office is pretty much, it's an arm of the state. It's a part of the state. So law enforcement, the prosecutors, everyone can kind of utilize that resource to them. Meaning, I mean, they're supposed to be completely independent and totally objective when it comes to their findings. However, it's completely impossible when you've got someone like a Michael Proctor or a DeChico who is trying to get the ruling as a homicide because that's going to help their case. Which, as we saw on the stand, there were text messages between Proctor and DeChico. That's why I brought them up, where they were communicating back and forth with one another about, or basically, they were razzing him, saying it was DeChico and somebody else razzing Proctor that he didn't get the homicide ruling. He got undetermined. So they were making fun of him for that because they would have got the right homicide ruling according to them. So, I mean, that's a big problem too, that conversation even took place, and the fact that people like Proctor think that they can go and influence the ME. So that's a big, big issue. So speaking of the ME, I want to switch gears here now to some documents I have ready for you. So this is a post that was done also on August 28th, because that is when, um, hold on, I'm on the wrong screen. There we go. That confused me for a second. um, there we go. All right. What was I saying? So this is a statement from Ted Daniel, also Boston 25 News, who we just saw. This is the full statement from the chief medical examiner. He posted this again August 28th, the day that Matthew Farwell was arrested. The ME's office says the Massachusetts office of the chief medical examiner is aware of the federal indictment related to the tragic loss of Sandra Birchmore's life. The medical examiner's office has fully cooperated with the U.S. Attorney's Office on this investigation and will continue to do so. To uphold the integrity of this active federal investigation and prosecution, the OCME respectfully declines to publicly comment on this matter at this time. So they're saying we're cooperating and we're not going to say anything else here, but we are aware and we're working with Josh Levy, basically. So that is their statement. I mean, there's really not much to make of it. I wonder if the office of the chief medical examiner, I wonder if they might be being looked at by the feds because of some maybe misconduct there. I don't know. I'm not saying that they are. I'm just saying it's a potential possibility if they're going and meeting with the ME first and saying, hey, we disagree with your findings. So, how'd you get there? And what information got you there? Because we need to know how you achieved the hanging by self um, ideations. All right, so let's move on now to Matthew Farwell's detention. He is now waiving his hearing. There was supposed to be a hearing this week, the 12th, I believe, September 12th. He was supposed to be back in federal court to talk about his um, the motion for um, the feds motion for detention and if they were going to, contest it. But he is waiving his rights right now for a trial or a hearing for this detention motion. So let's read what he has to say. The defendant, Matthew Farwell, through counsel, asks that this court enter a voluntary order of detention without prejudice. So he is saying, hey, man, I surrender for now. I'm saying I surrender, and you can have me in custody. And cancel the detention hearing scheduled for September 12th. Yeah, September 12th. All right, so as grounds for this request, the defense states that Mr. Farwell had his initial appearance before the court on August 28th, 2024. So he was arrested and arraigned on the same day. The government moved for Mr. Farwell's pretrial detention at that time. A detention hearing was scheduled for September 10th and then rescheduled to September 12th. After an opportunity to consult with his counsel, Mr. Farwell now asks the court to enter a voluntary order of detention without prejudice. So that means they might be able to come back and contest it later, but right now, no. They're just saying, let's we waive our right to this hearing and we're going to just stay detained until further notice. Um, yeah, so saving his right to request a detention hearing at a later date when his counsel has had additional time to review materials. So they're giving counsel more time. So this to me makes it seem like he might be trying to cooperate, at least on some level, because the lawyer needs time to prepare for said hearing. So in this case, I think the lawyer is going to, using a Brian Higgins term, suss out what they're dealing with and figure out what's the best route for Mr. Farwell. I don't think he's ever going to see daylight again, but you know what I mean. I think he's just going to be locked up indefinitely. All right, so um, Mr. Farwell further asks that this court cancel the detention hearing scheduled for September 12th, and it is signed respectfully Matthew Farwell by his attorneys Jane Peachy and Sandra Grant, Federal Public Defender's Office. So he's got some federal public defenders that are representing him as of now. So we shall see what happens. We won't be hearing about him going back to court this week as he was scheduled to do. We will find out maybe once they figure out what kind of discovery the feds have, they'll be like, nah, we'll waive it indefinitely. Who knows? Who knows? We shall see what happens there. So let's move on now to the civil case. So this is the memorandum of decision and order on the motion to compel the production of documents from the Attorney General's office. So if you remember the last hearing that we had for the civil suit, we were listening to the attorneys for William Farwell and others. Mostly William Farwell's attorney was asking for this. They had brought the motion forward, and they wanted the discovery. They want the AG's office, so Josh Levy's office, to fork over some discovery that they want. So here's the order based on that hearing. Defendant William Farwell, or William, filed the instant motion seeking to compel the office of the Attorney General, or the AGO, to produce documents responsive to a March 18th subpoena ducis tecum. None of the co-defendants opposed the motion, and at oral argument, plaintiff joined in the motion. So, Sandra Birchmore's attorney, or the estate of Sandra Birchmore, the attorney for the estate, had also joined the motion, saying, "Yeah, that would be great if we could get the AG's discovery." perfect. That would help our case tremendously. Only the AGO has opposed, replying primarily on the investigatory exemption. The only person opposing it is the AG's office. They don't want to turn it over. All right, so during the July 12th, 2024 motion hearing, the moving parties clarified that they did not seek materials which would constitute attorney work product. The categories of responsive materials in dispute were narrowed to 1. Materials provided to the AGO from the Massachusetts State Police, including observations and investigative activity, witness statements, and digital forensic evidence. And 2. Third-party records obtained by the MSP through search warrants. Following the hearing, the AGO submitted a hard drive to the court to conduct an in-camera review of the responsive materials in the possession of the court to determine. So, following the hearing, this happened. Okay, so the AGO submitted a hard drive to the court to conduct an in-camera review, basically like in chambers. They review the material, and it is now in possession of the court to determine whether the privileges asserted by the AGO protected such materials from disclosure. As set forth below, Williams' motion is allowed in part. In order for the investigatory exemption to apply, the court must consider whether the requested materials were necessarily compiled out of the public view, and if so, whether the AGO has demonstrated that their release would probably so prejudice the possibility of effective law enforcement that such disclosure would not be in the public interest. Here, William requested materials from the AGO not through a public records request under GL 6610, but through a subpoena pursuant to Mass R Civ P 45. Whether records are requested through a subpoena or a public records request, the court must evaluate whether the AGO has met its burden to demonstrate that the records are not subject to disclosure. The public records law presumes that documents held by a public agency are public, with the burden placed on the government agency to prove by a preponderance of the evidence that a record may be withheld. 20, General Laws 26th creates various exemptions to the scope of materials that are considered public records, including the investigatory exemption. These exemptions are strictly and narrowly construed. The investigatory exemption encompasses public policy concerns that include the prevention of the disclosure of confidential investigative techniques, procedures, or sources of information, and the encouragement of individual citizens to come forward and speak freely with police concerning matters under investigation. Among the considerations in determining whether the exemption applies are whether an investigation remains open and whether there has been public disclosure of the information sought. Further, although the application of the investigatory exemption does not involve a balancing test, the public has an interest in knowing whether public servants are carrying out their duties in an efficient and law-abiding manner. Having reviewed the materials at issue in camera and with these considerations in mind, the AGO has met its burden in regard to MSP's summaries of the witness statements, except for those so specified below. The recorded telephone calls of citizens not parties to the case and the affidavits in support of search warrants. So those are all going to be excluded from this, I believe. That's what they're saying, because the AGO met its burden for these items. The AGO has failed to meet its burden in regard to the digital forensic evidence it obtained, including but not limited to extraction reports, the records obtained by the MSP through search warrants. The AGO has also failed to meet its burden in regard to the AGO shared Stoughton PD file, Birchmore reports numbered 1, 6, 8, 17, 18, 22, 23, 24, 25, 27, and Canton PD reports. Although this court has determined that with respect to certain materials in its possession, the AGO has failed to establish that the investigatory exemption applies, this court specifically has not ruled that all such materials are public records. It is clear that certain materials do not meet the investigatory exemption. Um, it is clear that certain materials that do not meet the investigatory exemption may meet other exemptions, which are not currently before this court. I'm not going to read all that. It's just another statute that they're referring to in the footnote here. Basically, although certain materials are subject to discovery under the rules of civil procedure, because the investigative exemption does not apply, that does not designate such materials as public records. Accordingly, this decision does not abrogate any public agency's obligation to determine what exemptions are applicable and what materials are public records. All right. Okay. So 26A and C. Accordingly, the court explicitly extends the protective order agreed upon by the parties, see papers 55 and 56, to the materials that the AGO must provide. Finally, to the extent the AGO has raised arguments that the subpoena is overly burdensome, the argument is without merit as the information may be readily produced in a digital format. So the digital items, the digitally um, preserved data, they can easily hand that over in an electronic format. And that's what they're asking. That's what the judge is allowing them to have. All the digital forensic evidence as it pertains to extraction reports, records obtained by the MSP through search warrants. So those are and these files, whatever these files are. Um, yeah, so other things like their investigatory notes and summaries, those are not going to be discoverable, but just those things that we listed. Although this court has determined that, oh wait, we're past that. Finally, to the extent the AGO has raised arguments that the subpoena is overly burdensome, the argument is without merit as the information may be produced digitally. To the extent the AGO incurs an expense for production of a hard drive or similar device, William is obligated to reimburse the AGO for such reasonable expense. So if there's any expenses that need to be incurred, send it to William's attorney. All right, so the order is for the foregoing reasons, it is hereby ordered that William Farwell's motion to compel is allowed in part. The Office of the Attorney General is ordered to respond to the subpoena at issue by producing the digital forensic evidence obtained from the MSP, including but not limited to extraction reports, records obtained by the MSP through search warrants, and those records saved as AGO's shared Stoughton PD on all those files that we listed earlier. The motion is otherwise denied for any other kinds of discovery. The protective order shall apply to such materials until further order of the court. So whatever was under protective order is still under protective order, apparently. So that was the order for that. Who's their judge? Let's take a look. I forgot already. Claudine A. Clotaire, Justice of the Supreme Court. And in more news of William Farwell, this came out August 26th, the order. However, in between the hearings and that order, William Farwell has had some, I don't know, issues or problems with, I don't know, problems necessarily, but he's changed his representation. So let's take a look at these filings really quick. I just want to zoom them in. So his main attorney that we saw on the hearing, the last hearing for post-commission, this was a notice of withdrawal for David Bay. This came just August 27th. This was David Bay was the one that was on the call, and he did all the speaking for William Farwell and trying to get that AG's motion allowed, which they did in part. So David Bay, what does he say? Notice of withdrawal. Now comes counsel for William Farwell, attorney David Bay of Boyle Shaughnessy Law PC to provide notice of counsel's withdrawal of representation for William Farwell pursuant to Mass Rule of Civil Procedure 11C. Please find the notice of William Farwell's new counsel attached to this notice. So he has new counsel, which we'll get to in just a second. And here he apparently he had two attorneys because this is also another attorney coming from John W. Gilles, I don't know, however you say that. Gillies, sure, we'll go with that. So this guy, John, is also withdrawing from William Farwell's um, representation. And lastly, notice of appearance, which came August 23rd. I guess this was first before the other two came out. So maybe they saw the writing on the wall. Maybe William Farwell was like, you know what, this is probably going to go to the feds. Maybe they were approached by the feds and he was like, yeah, I need someone who can represent me better or something. I don't know because uh August 23rd he gets a new attorney and he files a notice of appearance saying, please enter appearances for Robert W. Connolly on behalf of defendant William Farwell in the above captioned manner. So that is his new attorney, Robert Connolly, and this was dated August 23rd, and again, Farwell was arrested the 28th, 5 days later. So did they see the writing on the wall? Was someone approached? I don't know. I'm not saying that they were, but I'm just saying it's a little odd, the timing, and we'll see what happens there because we're going to keep an eye on these. We're not going to let Sandra be forgotten. We're not going to let these guys get away with what they did to her. So, that being said, thank you guys so much for watching. If you or someone you know needs help, seek it out. You're worth it. You deserve it. You deserve better. You deserve to be treated with respect and love and kindness, all of you. And if you're not, don't accept it. Don't accept that from somebody else. So stand up for yourself, speak up, speak up for others that can't speak up. Sometimes sometimes you might be able to speak up for yourself, but sometimes there might be others who can't speak up for themselves and they might be needing help. And when you see that, do the right thing and speak up for them because maybe if more people had done that for Sandra, she would still be here today. And on that note, it's very sad, sad story altogether. I feel so deeply connected to Sandra in a way just because of reporting this and um, ugh, just the awful things that she endured. I can't even imagine. And I want her story told. I want her to be front and center. And that's why I'm going to continue talking about her and making sure that the right people go down for it. So thank you guys again so much for watching. And if you have any questions or comments, please let me know in the comments below. And I will see you guys in the next one. Thank you so much for watching. Take care. Bye now.